Hello everyone, this is Crypto Bit Law, back with another blockchain legal brief, and today we're going to discuss the SEC versus Ripple Labs case. And this is a case that has some pretty far-reaching implications with regards to the entire blockchain, cryptocurrency, digital asset space. It's a case where the SEC is suing Ripple Labs, alleging that Ripple Labs engaged in the unlicensed distribution and sale of an unlicensed security when Ripple released their XRP token. And the case has been in litigation for quite a long time now, and there were pretty major developments that happened today. So we're going to break down what these major developments are, go through them, parse them out, and then do a little analysis on them and relate them back to some of the facts at hand. But before we dive in, if you guys enjoy this content, please hit that like button and subscribe to our channel. We'd really appreciate that. We strive to continue to bring you some of the highest quality analysis and news and perspective on all things blockchain and crypto, law, policy, and regulation. So with that said, let's dive right on in. Okay, so here is the docket for this case. As we can see, it's Securities and Exchange Commission versus Ripple Labs. And it's out of the Southern District of New York. And if we scroll down to the most recent events, we could see two major events that happened today. Besides this one isn't as major as these two orders that were issued by the judge. And the first one up is an order denying a motion to strike a docket entry and another document, the motion to strike that was filed by the Securities and Exchange Commission. And this one will strike up as a win for Ripple. And we'll dive into this particular order, this docket entry, and then parse out why this is a win for Ripple. But the next one, just when it seemed like, oh, the tide was starting to shift in favor of Ripple, the judge comes back and issues this order. It's an order denying a motion to dismiss that was filed by the defendants, Ripple, pretty much. I think it's the two founders of Ripple, the individual defendants. So they filed a motion to dismiss the SEC's claims against the defendants. And this one is a win for the SEC. And so we'll dive into that one and see how that one is a win for the SEC. Okay, so first up, let's take the first order, the order denying a motion to strike filed by the SEC. Okay, so here is a copy of the order that was filed today, and we could see, I guess we'll go through just the summary right here. It states, plaintiff, the United States Securities and Exchange Commission, the SEC, brings this action against defendant Ripple Labs Incorporated and two of its senior leaders, Bradley Garlinghouse and Christian A. Larsen, alleging that defendants engaged in the unlawful offer and sale of securities in violation of, and they state the law of the Securities Act. Ripple asserts as an affirmative defense that it lacked fair notice that its conduct was in violation of law, in contravention of Ripple's due process rights. And this was in their answer. They asserted this affirmative defense in their answer to the complaint that was filed against them by the SEC. So the SEC moved to strike Ripple's fair notice defense under a federal rule of civil procedure. And for the reasons stated below, the SEC's motion to strike that fair notice defense was denied. So this is a complete win for the defendants Ripple Labs, Garlinghouse, and Larsen. So a copy of this order is going to be linked down in the description below. If you'd like to go through it in more depth, feel free to do so. But I'm just going to stick to the major points listed in the court's analysis. This pretty much has to deal with how the SEC kind of became aware of what Ripple was up to and how the SEC met with a platform that was considering listing XRP, and the platform sought guidance on whether the SEC considered XRP a security. And during the meeting, the SEC did not say that it considered XRP to be a security, and the platform proceeded to list XRP. And SEC officials have also publicly stated that digital assets may be considered securities under certain circumstances. And then we get into the bulk of the analysis. So here's where we really start applying these legal standards to the facts of this case. So as we can see, points of note, it states, under federal rules of civil procedure, Rule 12F, a court may strike a pleading from any insufficient defense. And that's what's going on here. Motions to strike an affirmative defense are disfavored and should generally not be granted. And then here's some jurisprudence, Thrasher and Honing. In ruling on such a motion, courts deem the non-moving parties' well-pleaded facts to be admitted, draw all reasonable inferences in the pleader's favor, and resolve all doubts in favor of denying the motion to strike. So, as we could see set up by the legal standard, the SEC had the ball stacked against them from the get-go. The legal standards are that motions to strike an affirmative defense are disfavored and should generally not be granted. So they were going to have a tough time getting this thing granted anyway. I mean, they would have really had to bring the pain in order to get this thing granted. But continuing on, we see that to succeed on a motion to strike an affirmative defense, the SEC must show that 1, there is no question of fact which might allow the defense to succeed. 2, there is no question of law which might allow the defense to succeed. And 3, the plaintiff would be prejudiced by including the defense. So, in order to succeed on a motion to strike the affirmative defense, the SEC would just have to prove that in terms of the law, the facts, and just the overall nature of the case, the defendant's affirmative defense is complete and utter BS and has no basis in law, fact, and it's actually going to prejudice the plaintiff by making the whole process more arduous. So that would be what the SEC would have needed to show in order to get the affirmative defense stricken from the record. Continuing on, it says, therefore, the party pleading here, Ripple, must support its defenses with enough factual allegations to make them plausible. So all they need is to support their defense with facts that could make the defense seem plausible, right? And so here we get some application. A fundamental principle in our legal system is that laws which relegate persons or entities must give fair notice of conduct that is forbidden or required. So this is part of the fair notice defense, right? This clarity requirement is essential to the protections provided by the Due Process Clause of the Fifth Amendment. As an affirmative defense, Ripple pleads that it lacked and the SEC failed to provide, quote, fair notice that its conduct was in violation of law, in contravention of Ripple's due process rights. The SEC argues that the court should strike this defense at the pleading stage because it is a legally insufficient defense on which Ripple cannot prevail as a matter of law. The SEC also contends that it would be prejudiced by Ripple's defense because the defense would lead Ripple to seek intrusive discovery. After considering the SEC's arguments, the court holds that the SEC has not met its burden of showing that Ripple's fair notice defense should be stricken at this time. Okay, so Ripple wins on this one. Let's see a little more as to why. The court must first determine what Ripple did before addressing whether the statute fairly apprised Ripple that its conduct was prohibited. Okay, so this is getting into the court wanting to learn more about the background and the facts of this case before just willy-nilly throwing out their defenses. They further state, the court does, at the pleading stage, the court's examination of Ripple's conduct is limited to facts pleaded in Ripple's answer, the undisputed facts in the amended complaint, and any fact of which the court may properly take judicial notice. As discussed above, Ripple states that XRP's price bears no relation to Ripple's activities. It also asserts that it has not sold XRP as an investment and that it has no relationship with the vast majority of XRP holders. At the very least, these facts, if true, would raise legal questions as to whether Ripple had fair notice that the term investment contract covered its distribution of XRP, and the court may need to consider these questions more deeply. And so they're pretty much saying they want to do a little more digging. The court wants a little more analysis. Thus, accepting all of Ripple's pleaded facts as true and drawing all reasonable inferences in Ripple's favor, as the court must do at this stage, it concludes that the SEC has not met its burden of demonstrating that there are no questions of fact or law that might allow the defense to succeed. None of the cases cited by the SEC support a contrary result. In short, the SEC has cited no case law where a court has stricken a fair notice affirmative defense at the pleading stage, and the court is not persuaded that doing so is appropriate here. Moreover, the SEC has not shown that it will suffer undue prejudice as a result of the continuation of Ripple's fair notice defense. An increase in the time, expense, and complexity of a trial may constitute sufficient prejudice to warrant granting a plaintiff's motion to strike. However, a sufficiently pleaded defense should always be allowed if timely filed, even if it will prejudice the SEC by expanding the scope of the litigation. The SEC does not contend that Ripple's affirmative defense is untimely, and the court shall not conclude at this early stage of the case that Ripple's defense is invalid. They're still calling this the early stage of the case. Oh, man. Accordingly, the SEC's motion to strike Ripple's fair notice affirmative defense is denied. All right, so now that we looked at the first order, let's take a look at the second order. This is the order that favors Ripple. This is an order denying a motion to dismiss, and it denied the individual defendants' motions to dismiss. And so let's dive into this and see what this one's all about. Okay, so as we can see here, the overview states that the individual defendants move separately under Federal Rule of Civil Procedure 12b-6 to dismiss plaintiff's complaint for failure to state a claim. Larsen and Garlinghouse filed motions, and for the reasons stated below, the individual defendants' motions are denied. So let's take a look and see why. All right, so before we continue, I'm just going to give you the general legal standard and then just kind of go over the ultimate conclusion, because this particular order is very dense. I think it's like 30-something pages, and we'd be here all day going through this, but I don't quite have the time to go through all this at this point, although we might do a deeper dive a bit later. So we're just going to kind of keep it simple and just give you a broad overview. So the legal standard to survive a 12b-6 motion to dismiss is that a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. So it's all about plausibility. These are the standards for a motion to dismiss. A claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw reasonable inference that the defendant is liable for the misconduct alleged. A plaintiff is not required to provide detailed factual allegations, but he must assert more than labels and conclusions. Additionally, where a particular state of mind is a necessary element of the claim, the pleadings of that state of mind must be plausible and supported by factual allegations. On a 12b-6 motion, the court may consider only the complaint, documents attached to the complaint, matters of which the court can take judicial notice, and documents that the plaintiff knew about and relied upon when drafting the complaint. And so what the court does here is they go through the application of that standard for the motion to dismiss against all of these different subheadings that were component parts of the complaint, like aiding and abetting. And, the court does an analysis on it. To hold a defendant liable as an aider and abetter in a civil enforcement action, the SEC must plead and ultimately prove 1, the existence of a securities law violation by the primary party, 2, knowledge of this violation on the part of the aider and abetter, and 3, substantial assistance by the aider and abetter in the achievement of the primary violation. Right, and then they do a little conclusion based on all of the legal standards and the facts of this case, And we state here, the SEC alleges that the individual defendants aided and abetted Ripple's violation of Section 5 by assisting Ripple's unregistered sale of XRP. For the purposes of their motions, neither Larsen nor Garlinghouse argue that Ripple did not violate Section 5 by making unregistered sales of XRP. Therefore, the court assumes that the SEC has adequately alleged the first requirement, the existence of a security law violation by the primary party. In order to prove the remaining In order to prove the remaining requirements, the SEC must show that the individual defendants, quote, joined the specific venture and shared in it, and that their efforts contribute to its success. And then they go into knowledge. Individuals argue that the SEC sufficiently alleged that they had knowledge of Ripple's alleged violations. And then we get some more standards. And then we get some conclusions. Here. The court finds no basis for the conclusion that Congress intends for willfulness requirement to be posed. Individual defendants cite no binding authority to impose a willfulness requirement. Individual defendants generally mischaracterize these cases' holdings. And then we go pretty much case in point like this, issue after issue. We'll just go through the major issues. Substantial assistance. Larsen also challenges the SEC's allegations regarding his provision of substantial assistance in furtherance of Ripple's alleged violations of Section 5. The SEC's allegations. Turning to the SEC's allegations, the court finds the SEC had plausibly alleged the individual defendants had knowledge of or recklessly disregarded the facts that allegedly made Ripple's sale of XRP amount to the unregistered sale of securities, and that Larsen provided substantial assistance. Individual sales, domesticity. Let's see what else. That's a big section. And that's a really big section. Predominantly foreign. Then we start getting into here. The court finds that the individual defendants' offers and sales were not predominantly foreign. These offers and sales were made by U.S. residents, involved alleged securities issued by a U.S. company, concerned at least some of these offers and sales made on U.S.-based platforms, and included at least some offers and sales made to U.S. purchasers. Thus, the application of Section 5 to these offers and sales would, quote, enhance the confidence in U.S. securities markets and protect U.S. investors. Accordingly, the individual defendants' motions to dismiss the SEC's claims based on their individual offers and sales are denied. And then we go to timeliness. And Larsen's motion to dismiss the SEC's claims for monetary civil penalties is denied. Because the SEC's claims could not accrue for each offer and sale until defendants actually sold or offered XRP, the court does not find that they accrued when the defendants began to make unregistered offers and sales of XRP generally. So in that argument, the individual defendants were trying to claim that the SEC's case against them was untimely, right? And then they tried to cite some sort of statute of limitations or standard that would limit the SEC's ability to file a claim against them based on timeliness, and the court just tossed it. So yeah, for all the reasons, if you'd like to dig into deeper detail of what's going on in this order, it's going to be linked down in the description below. But ultimately, the big takeaway is that for the foregoing reasons, everything listed above here in this order, the individual defendants' motions are denied. And so pretty much the court denied the defendants' motion to dismiss the plaintiff's complaint for failure to state a claim. So this is a win for the SEC. So ultimately what we have here is one win for Ripple Labs and the individual defendants and one win for the SEC. And pretty much this is a wham-bam back and forth battle of attrition. This is going to be a battle of attrition between these two parties, the SEC and Ripple Labs. And I mean, I think it was even interesting that the court referred to this as still being in the early stages of the litigation. Although it feels like so much is played out, I suppose we're still, grinding through the thick of it in the early stages, the court said. And anyone that's going to come out and tell you that this is just such a slam dunk for Ripple, I think that they're being a little hyperbolic. I wouldn't say that this is such a slam dunk for Ripple, because I mean, if they're going to say that, at the same time, would they be willing to take the court's denial of the individual defendants' motion to dismiss Ripple's claims, or the SEC's complaint against them? Would they claim that as a slam dunk as well? Right? So I think this pretty much balances the scale. This one win for Ripple and the other win for the SEC. I feel like it kind of balanced the scale, and I think that ultimately, based on what I read in these orders, it seems like the judge, Annalisa Torres, she's treating this pretty fairly on both counts. Really kind of sticking to the law, applying it to the facts, and just kind of being a neutral, I guess, judge or adjudicator of what's actually going on here. So I think it's really interesting developments. I'm sure that there's going to be more and more that comes. Maybe there's going to be the big bombshell that's just going to blow this whole case out of the water and just leave one party with their feet to the fire, kind of begging and screaming for mercy. But when that happens, we'll be sure to let you know. But until it does, we'll keep tabs on this for you. Please let us know what you think in the comments down below. We'd love to have your feedback and know your opinions on where you think this case is going to head. Who do you think is ultimately going to win? Just your overall opinions on what's going on here. And once again, as a reminder, if you enjoyed this content, please hit that like button and subscribe to our channel. We'd really appreciate that as we strive to grow and kind of expand our reach and get our message out there. So with that said, thanks again for watching, and we will see you all in the next video.